Hello everyone. We have seen that though an agreement possesses all the essential elements of a contract, it may not be enforceable if the agreement is declared void by any law in force in the country. The agreements which have been expressly declared void include agreements by incompetent parties, agreements made under mutual mistake of fact, agreements with wholly unlawful consideration or object, or agreements with consideration or object partly unlawful, agreements without consideration, agreements in restraint of marriage, trade, and legal proceedings. These agreements have been dealt with in the previous presentations. There are still some more agreements which have been expressly declared void, which include agreements which are uncertain, contingent agreements to do or not to do anything if an impossible event happens, agreements to do impossible acts and reciprocal promises involving doing legal acts as well as illegal acts, the promise for illegal acts being void. The first category is agreements which are uncertain. Agreements, the meaning of which is not certain or which cannot be made certain, are void because certainty is an essential element of valid contract, and where the meaning is not clear, there is no agreement at all in law. For example, where A agrees to sell his house to B for rupees 15 to 16 lakhs. There is nothing here to show which of the two prices was to be given. The agreement is void. But where A agrees to sell to B 1000 kgs of rice at a price to be fixed by C, the price can be made certain by asking C to fix the price. There is therefore no uncertainty to make the contract void. The next category of void agreements is the wagering agreements. Here, there is an agreement between two parties by which one party promises to pay money on the happening of some uncertain event, while the other party promises to pay if the event does not happen. For example, when A promises to pay a sum of money to B if it rains in the evening, and B promises to pay the same sum of money if it does not rain, it is a wager. But where competition or games involve skill, or where a subscription is made to contribute towards prize to be awarded to the winner of a horse race, or in the case of share market transactions involving delivery of stocks and shares and contract of insurance, are not wagering agreements. Now, how is a contract of insurance different from wagering agreements? In insurance, the insured has an insurable interest in the subject matter. In wager, there is no such interest. In insurance, both the parties are interested in protecting the subject matter. In wager, only one party has such interest. Contract of insurance is a contract to indemnify the loss due to accident, and the amount is assessed on the basis of the loss suffered. In wager, the amount is fixed. Insurance contracts are beneficial to public, whereas wagers serve no useful purpose. The calculation of risk in insurance contracts are scientific and actuarial, whereas wagering agreements are nothing but a gamble. Now, what is the effect of a wagering agreement? They are expressly declared void and hence cannot be enforced. Fresh agreements made subsequent to the original wager is also void. Where money is deposited with a stakeholder to be paid to the winner of a wagering agreement, it cannot be recovered by the winner. The loser can recover his deposit from the stakeholder. But if the stakeholder pays money to the winner, the loser cannot recover it from him. For example, where during a cricket match, A and B enter into an agreement where A promises to pay rupees 5,000 to B if cricketer X hits a century. B promises to pay A rupees 5,000 if X does not hit a century. Both A and B deposit 2,500 each with C, who is required to pay rupees 5,000 to the winner of the wager. Here, if X hits a century and C refuses to pay rupees 5,000 to A cannot recover the money because it is a void agreement. But B can recover his share of rupees 2,500 from C. But if C pays rupees 5,000 to A, B cannot recover his share of rupees 2,500 from A because here again it is a wager. Depositing the money with C is a collateral agreement and it is not affected by wagering agreement. A contingent contract to do or not to do something on the happening of an event becomes void when the event becomes impossible. For example, where A promises to pay B a sum of rupees 2 lakhs when he marries C. When C dies before marriage, the contract becomes void. A voidable contract becomes void when the party whose consent is not free rejects the contract. For example, A consents to pay rupees 20,000 to B under B's immediate threat to commit suicide if the amount is not given. Subsequently, when B withdraws from committing suicide, A can refuse to pay the amount by rejecting the contract as it becomes void. A contract becomes void by supervening impossibility or illegality, where A contracts to sell his farmhouse to B for a certain sum, but before A could hand over the farmhouse, it is destroyed due to a fire accident. Here, because of supervening impossibility, the contract becomes void. Where a party rescinds a voidable contract, the other party need not perform his part of the contract, and if any benefit is received by the party rescinding the contract, it has to restore to the other party the benefit so received. When an agreement or contract is void or becomes void, the person receiving benefit under such agreement has to return it or compensate for it to the party from whom such benefit is received. But where the contract is known to be void when they entered into it, or where a party to a contract is incompetent to enter into a contract, restitution or restoration of benefit to the other party need not be made. The court may, however, order a minor to restore the benefit received by him by misrepresenting his age under a void contract on grounds of equity. Regarding legal formalities, a contract may be made orally or in writing. The legal effect is the same for both oral and written contracts, but it is in the interest of the parties to have the contract in writing. Where the law prescribes that the contract should be in writing, it has to be in writing. For example, gifts, lease, sale, and mortgage of immovable property, etc. Where the law requires that the contract has to be in writing, stamped, and registered, it has to be executed accordingly. For example, agreements involving transfer of immovable property under the Transfer of Property Act. So, when legal formalities are prescribed, they have to be strictly complied with, or else the agreement cannot be enforced by law. Coming to contingent contracts, a contract may be an absolute contract or a contingent contract. In absolute contract, the promisor binds himself to perform in any event without any condition. In contingent contract, the party agrees to do or not to do something if some event collateral to such contract does or does not happen. Here, the performance of a contract depends upon happening or not happening of an event in future. The event has to be uncertain and must be collateral or incidental to the contract. Contracts of insurance, indemnity, and guarantee are examples of contingent contracts. Now, what are the rules regarding contingent contracts? Contingent contract cannot be enforced until the event happens because they depend on the happening of an uncertain future event. If the event is impossible, the contract becomes void. When a contingent contract depends on the non-happening of an event, the performance of such contract can be enforced when the happening of the event becomes impossible. For example, A agrees to pay a sum of money to B if a certain ship does not return and the ship sinks. The contract can be enforced because the ship that sinks cannot return anyway. If a contingent contract depends upon how a person would act at an unspecified time, the event becomes impossible when such person does something which makes it impossible for the person to act within any definite time, unless there is a further contingency. For example, if A agrees to pay a sum of money to B if B marries C, C marries D. Now it's impossible for B to marry C unless D dies and C agrees to marry B, which is a further contingency. Contingent contracts to do or not to do anything on the happening of a certain event within a fixed time becomes void if the event does not happen or if its happening becomes impossible before the expiry of the time specified. A promises to buy a car for B if B clears civil services exam and becomes a collector. If B does not clear the exam within the limited attempts available or meets with an accident because of which he could not take the exam in the last attempt, the contract becomes void. Contingent agreements to do or not to do anything if an impossible event happens are void irrespective of whether the fact is known or not to the parties. For example, A agrees to pay a sum of rupees 20,000 to B if B's horse wins a race. Horse is dead when the agreement was entered into. Here the contract is void because it is impossible for a dead horse to win a race. Now, how are contingent contracts different from wagers? Wager consists of reciprocal promises, but a contingent contract need not. A wager is contingent in nature, that is, depends on the happening or not happening of a thing, whereas a contingent contract is not a wager. Wagering agreement is void, but a contingent contract is valid except under certain circumstances. In wager, the parties have no interest in the subject matter of the agreement. This is not so in a contingent contract. In wager, the future event is the sole determining factor. In a contingent contract, it is collateral. This, in brief, is about agreements not declared void and contingent contracts. Thank you.